Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. He is one of the most influential SEP experts in Japan, one of the organizers of the so-called SEP study group in Japan, and a partner at Sonderhoff Einsel, where he worked on many SEP cases. I'm so happy to have here on my SEP couch today, Shogo Matsunaga-san. Shogo, very welcome to the SEP couch.
Well, thank you. I've been looking forward to be a part of your SEP couch, speaker, and I'm so thankful that just include me in the list of your podcast. Thanks again.
Well deserved, Shogo. I can tell you that. And I'm starting, like always, to understand more about you as a person, your career, and how you ended up working on SEPs. So if you give us a little bit of an overview of who you are and your career steps.
Okay, thanks. Thanks again, Tim. I'm a Japanese IP counsel fighting against the prejudice that Japanese court would never award an injunctive relief based on SEP. I became an IP attorney in private practice in my late 30s. And until then, I worked for a non-ICT company, and my change of job was in 2008. And previously, I experienced joint industry academia projects and licensing negotiation that I loved most. And when I became an outside counsel, I had a strong interest in SEP because it's a monopoly light, not only to a particular technology, but also to the market itself. And their nature is quite different from traditional patents in that they conflict with competition law. And when Apple-Samsung lawsuit was pending in Japan for the first time in 2012, the Ministry of Economy, Trade and Industry, which is often called METI, established a SEP study group that Team kindly introduced, consisting of industries and academics and lawyers. And luckily, I was invited to be a part of it, a member of it. Then the first front royalties were recognized in the United States in the Microsoft Motorola case, to be followed by the Innovatio case back in 2013. So I spent a year at the University of Washington in 2013 as a visiting scholar to study front royalty calculation and also the standard setting practice. And after returning to Tokyo, I began to receive consultations on SCPs and SCP lawsuits, which until then had only been on my personal academic interest. Thereafter, I was appointed as an expert committee member to METI and JPO and have been involved in various guidelines and studies on SCPs by Japanese government. And currently, you believe it or not, I represent several SCP litigations in Japanese courts and also advise IoT companies in obtaining front licenses.
Great. That's a great overview and well understood that you have become an SEP expert here. Before we jump into the more specifics and details on SEPs in Japan, tell us a little bit about Sonderhoff Einsel and your current customer services that you provide, your client base on SEPs. Is it purely Japanese companies? Is it also companies outside of Japan? And if you don't feel comfortable with naming them, just to get us an understanding who you're working with.
Yeah. Okay, well, thank you. Sonderhoff Einsel is a law firm with a long history. It was founded in 1910 by a German lawyer to assist German and European companies as they began to entering into a Japanese market. And in 1914, a major corruption case involving Siemens led to the cabinet's resignation and Prime Minister's resignation at the time, which I learned about too in my elementary school history class. And my son and daughter also knows about the case because of that. It still remains in the textbook of history at the elementary school. And at the time, Dr. Vogt, the founder of our firm, worked as a defense attorney of the Siemens management. I found it really interesting. And interestingly, when the World War first broke out in 1914, Dr. Vogt was drafted in the German army to fight against the Japanese troops and fought with them in Tsingtao, China. However, he was taken captive by the Japanese after that. And even more interestingly, while he was in the prisoner of war camp where German soldiers were interned, he was allowed to interact with the local Japanese citizens. And what he did afterwards was that he organized an orchestra and conducted the first performance of Beethoven's Ninth Symphony in Japan. Impressively, the story was made into a movie in Japan back in 2006. And the role of Dr. Vogt was played by a very famous movie actor. And this is actually the DVD that we all have in our firm. And then we were kind of encouraged to just go through this movie. So I've been watching this movie over and over again.
Quite some history there.
Yeah, right. And sorry, that's about the clients, I think I've gotten too far off the topic, sorry. But since then, the firm has continued as a full service law firm, mostly supporting European listed companies and their Japanese subsidiaries. And the industries we serve are varied, but many are tech companies. And therefore, intellectual property is at the heart of our practice. And many of my clients, also European companies, such as members of Avances licenses. But recently, I have also increased the number of Japanese companies, mostly in IoT areas. And then I'm helping them in obtaining front licenses. And the ratio about European companies and Japanese are about 7-3, I guess.
Interesting. So you still have some of the German DNA in your firm?
I believe so, yeah.
Very good. Great. Thank you for that overview and background, Shogo. Now to SEPs in Japan. I think you said that already in your introduction a little bit. There's some perception of Japanese courts that may be wrongly perceived. And I would wonder then, why do we see yet just a few SEP cases that really made it to the court? What is the wrong perception here? Do you also see advantages of Japanese courts should a SEP case brought in front of the court? What's your opinion there?
Yeah, firstly, that's correct. Unfortunately, since Apple Samsung IP High Court decision that was handed down in 2014, it's already 10 years old. And there have been no court decision handed down in Japan that provide predictions of conduct on the obligation of good faith negotiations or front calculations, front royalties. But we have some cases. So in terms with the importance of the judgment, I have to conclude that the Apple Samsung decision is still only the norm. And in this context, the good faith negotiation guideline 2002 was designated to be referenced by the courts. But unfortunately, as far as I know, it has been completely ignored by both Tokyo District Court, IP High Court, even when a party insisted on a reference. So, but at the same time, I never considered the Grand Panel's decision of Apple Samsung case was anti-patent ruling. Can I continue the reason?
Please do, please do.
Yeah, thank you. So it is often criticized that this only sole decision is friendly to patentee, but I have a different idea. Firstly, in terms of damages, the ruling awarded a royalty about 1 cent per iPhone 3, iPhone 4, and iPad first and second generation. However, in this case, only one 3G standard SEP was enforced. So if one says that the calculated value is still low, the cause would be the aggregate royalty rate that was recognized by the court. But in this lawsuit, both Apple and Samsung coincidentally submitted the exact same paper in the United States as the evidence of our aggregate royalty rate for handset. And that the paper concluded that the aggregate royalty rate for the handset was 5%. At the time, I remember the discussion in the United States was about avoiding the risk of vague and abstract royalty stacking idea, as seen in Microsoft, Motorola, and Innovatio decisions. And compared to 4G and 5G, where we have seen some estimates that aggregate royalty rate for handset is even about around 30%. I think it was a very conservative estimate. Of course, the number of SEPs and their relative value may differ from now. But therefore, given the discussion of royalty stacking at the time and the fact that there was only one SEP was enforced, I do not think it is necessary to assess that the royalty rate found by the court was anti-patent. And with regard to injunctions, the court ruled that the implementer must prove its willingness to take a front license. I think this part is pro-patent enough, isn't it?
So,
right? Yeah.
And you would expect that injunctions would be possible in Japan?
Oh, yes. But however, there was a problem. The court ruled that the finding that the implementer was unwilling had to be strictly determined by the court. And there was no criteria provided in this regard. So the meaning of this statement is difficult to understand. So some scholars have interpreted it to mean that unwillingness of the implementer is exceptional, which I don't take. However, this interpretation should be clarified by the accumulation of subsequent court cases, and we still look forward to it. And as you know, nowadays the court in Germany, the UK, and the Netherlands, and the US, and India also are looking harder at the implementer's patent holdouts. Therefore, subsequent court decisions should eventually build up an interpretation that harmonizes with international case law on this unclear norm. And I'm sure that several rulings and decisions will be handed down by Japanese court this year or early next year. So I would like to ask the audience of this program not to give up on the Japanese courts and keep a close eye on them. That said, it is not fair, in my opinion, to conclude that the Grand Panel decision was anti-patent, also from the injunction perspective.
Thank you, Shogo, for these great insights. This is super exciting. I know that there have been many cases that almost made it to court in Japan already in the past. So that you're predicting we will see something later this year is something that I definitely want to observe more. I think SEP licensing, we all is global markets. And obviously, therefore, we should also use the worldwide venues, and Japan is one of these important venues here. When it comes to Japan,
I hope so.
we all hope so. When it comes to Japan, Shogo, and you also said that in your CV, the Japanese government has a lot of initiatives and guidelines, and I want to just touch on these a little bit because reading those sometimes, at least to me, feel quite, let's say, academic or theoretical, and there are principles and guidelines out there. I think one that is often cited is the manual of Hantai, But there's also other guidelines published by METI, the organization that you also are involved with. Can you tell us a little bit more about these guidelines? At least what I hear, maybe these are rumors, these are often perceived as, again, anti-patent, pro-implementers. And can you tell us more about these? Are they used? You think they will be used in courts? Who reads those guidelines?
Okay. Yeah, thank you for referring those number of guidelines. And then you referred to Hante as well, right?
Also, yeah.
Okay, so your comment about Hante being the most known or something is quite shocking to me.
Okay.
And the reason is that Hante was started based on the idea of the JPO commissioner at the time. And that she stated that JPO would undertake the SEP essentiality test at the low cost, but it has not been successful at all. And every examiner at JPO hates to continue now. So I do not like to just put the highlight on it, but I have to just continue. So in this topic. So speaking of the achievement of Hante, a German company has only used the service once, but they did not obtain the good result out of this procedure. And at the time of launching this, system, a few Japanese SEP holders supported the idea of the JPO commissioner. However, no one has ever used Hante or even think about using it, because it is said the main reason for this is that result of essentiality decision are published on JPO's website, and the decision is not binding on the court. So even those Japanese, well, they are ICT companies, and then had lots of discussion internally after the launch of the this procedure, and then they decided not to go with it. So
Just
that's
one interesting comment here. That sounds a lot like the EU proposed SEP regulation where claim trust will be public on websites. Just a comment.
Well, I don't think it's quite practical. Especially the registration of all SEPs and then restricting the right to file a suit. Well, it's against the constitutional right, as the very famous judge stated before. I fully agree with him. And then, well, if it were in Japan, the same argument will occur, and even implementer will not be fully support such the system or idea. So we are taking a really close look, of course, but well, I see lots of the homework is ahead of the people who's pushing this project, I guess.
Understood. And there are also these three principles I keep reading about. License to all is one, top-down approach, proportionality rule. At least number 1 and 2, I know SEP holders really don't like very much, and these are often criticized. Again, are these principles that are used often? What is their power in Japan?
I see. So I understand that you are referring to a METI's guide that was issued back in 2020, and that consists of 3 elements of the policy that METI at the time wanted to pursue.
But in your practical experience, Shogo, is that part of a licensing negotiation typically, or are these principles used?
Not at all, because everyone knows, even in Japan, the result of the series of Daimler case in Germany. So if for example, automotive OEM or any manufacturer of finished product stop the negotiation and insist the license to all doctrine, then they will face the really critical risk in Germany and maybe UK, Netherlands, or even India nowadays. So even in the daily negotiations where Japanese implementers are involved, LTA argument is less and less seen, even at for the company who is not so experienced in front negotiation.
Understood. Yeah, I think the case law has proven this license to all wrong. I think there have been also some anti-competitive cases about Avanti's platform, and
Right.
I think the case law at least all went to one direction. But talking about Germany is a good point. Germany and Japan are often compared as being very similar markets. Both markets have large automotive OEMs. Japan has its Toyotas, Nissans, Hondas. We have our Volkswagen, BMWs. We have a supplier industry, the Continentals. You have Denso and others. Still, SEP enforcement in German courts is treated quite differently to Japan. At least when we talk about the approach. Can you tell us a little bit about the court differences, Germany, Japan, and who do you think is the more effective one, and why, and what may need to change, and what are the other jurisdictions to make this a better system?
Are you asking about the enforcement to IoT implementer who's not the specialist in the technology in question?
For example, automotive 10 years ago also was not experienced. So I think, time shifts from one industry to another. But, what's your general perception of the German court compared to the Japanese court and how they, treat things?
Right. Well, actually, not only the industry, the component of industry, but also the legal system itself has a similarity between the countries, because our mother law is mostly Germany, and our IP system is a little bit twisted under the influence of the US government. But we are a civil law country, and then learn a lot from German system of civil law and civil procedure law. So, well, of course, we have the injunctive relief. And once the infringement of patent is constituted, it is automatic that the right holder can pursue the injunctive relief. It's totally the same. But, well, again, since we only have the one ground panel decision that is useful, so we cannot fully compare it with the German case law where we see plenty of cases. But the judge's mindset, I would say, is all the same. But unfortunately, there's no accumulation of the cases after Apple Samsung. So this is the reason why you have this question. But I would say, because I have several pending cases now, I see some differences that, well, Japanese judges are still hesitant to take a harder look on implementers' holdout. This may be the cause. The case will be handed down in the future, in the near future, this year and next year, as I said before. But if you might be witnessing that such difference, if such attitude of the Japanese judges continue, and then the hesitance of this the Japanese judges may from their limited the experience because of the number of cases, I would say. And of course, the one thing is the pressure that was formed by Japanese government in the former number of the guidelines, and then where Japan is the country, the automotive industry is the dominant industry, as is the case in Germany. Well, that such influence has working in their mindset to some extent, because SEP is such a monopoly right to not only to the invention but also to the market itself, as I previously mentioned. So this kind of thing can be influential to the judge's mindset still.
Well understood. And it also, as I think, comes back to the question, what is a willing licensee, right? And how is that defined and how strong of a position a court takes? But that's interesting. And I always thought that's the beauty of SEPs. We have patent law, we have contract law, because in the end, it's a license contract. And then we have competition law because of that monopoly position. So as a lawyer, you have to be in all three, right?
Right.
And now talking about contracts, one thing and one reason many people say the whole automotive litigation, let's say battle, there was a time, there was litigation in automotive space every month, every week. A lot of that was caught. Fortunately, those times are over, right? But part of the reason many people said was contracts from a supplier to an OEM, in particular, that indemnification clause, basically saying, hey, I'm going to supply you my connectivity box, and all the patents in there are, the third-party rights I take on me. However, then that supplier couldn't take a license and the OEM had to take the license. So we had the dilemma of a, internal contract and the law. And I think that at least in Germany, the industry learned about that. I think the main problem here was also that the royalties were not calculated into the equation of supplying a product. And a lot of the indemnification clauses were eliminated, at least in the automotive industry. How is that in Japan? What is your observation there? Especially now you work a lot with new industries like IoT. Is indemnification still an issue? Will we see that? And why is it so critical?
Oh, thank you, Tim, for a good question. You are right. The patent indemnification is a contract that is based on the premise that it is possible to evade someone else's patent. So in such an indemnification agreement, we have to exclude SEPs that cannot be possibly avoided if the standard is deployed. And since this is totally the affordability issue, the supplier will have to choose to go out of business otherwise. And only finished product manufacturers can solve this problem. And if they do not understand that SEP loyalty is a standard essential cost, they will damage their supply chain and the negative effects will be passed on to themselves. Moreover, they're going to miss out on competition in the ever-evolving area of standard technology. And as you assumed, even in Japan, it is remaining as a very crucial topic. But on the other hand, while I'm assisting so many IoT companies who's a willing licensee but don't know how to do and have a limited sourcing internally, well, they changed the mindset, of course, and then knowing that the big failure of Daimler in Germany and some even Japanese automotive company who were sued in Munich as well, they get to learn what the things about, what's the difference of SEP from the ordinary patent. So I see many changes nowadays. What I can speak in this regard is that some non-automotive finished products manufactured have specified in their contracts to exclude SEPs clearly from patent indemnification clause, and I have assisted them to do this. And I don't know about each of the whole industry group, but I think such companies will increase even in Japan. On the other hand, the situation in Japanese automotive industry is still tough, although the tier 1 and tier 2 suppliers are still struggling to find out a way to resolve such unhealthy conditions.
Which I also understand. I think we have to still consider the market pressure that if you're the only one who is not indemnifying, you're losing your competitive edge, and the others are still indemnifying, and that clause is also part of, a competing industry where OEMs have the power usually, right, and push down on suppliers. So that's some dynamic. I think also some of the telecoms had to understand that the dynamics in the automotives, the way they are. But it's interesting, Shogo. Thanks for these insights. I think it's good to see some change, and it does make sense that indemnification at some extent excludes SEPs. Also for for the suppliers to have more clearance on SEP risk, I think. Very interesting. When we talk about IoT connectivity and all this, of course, 5G has over the past years been a big topic. I hear in the Japanese news a lot, Japan is lagging behind 5G, which I find always quite, I also have a question mark what that actually means, because 5G is obviously not only the companies who own SEPs in 5G, it's also about infrastructure. It's about the companies using 5G. So it's a very complex question. But in terms of that, I mean, maybe why would that be a perception in Japan? Why would Japan be lagging behind? If you think about the industry in Japan and connectivity in bigger terms, where are we in Japan? And are they really lagging behind, or is it just a different industry with different sectors?
Well, in terms with the mindset of implementers, they are changing a lot, and they're looking for actively utilizing the technology after taking licenses. So, well, there are exceptions, and then such arguments are mostly relates to the attitude of automotive sector, I would say. For example, I recall your previous seminar you held 2 years ago already, and then you introduced Japanese audience to the latest development of 5G connectivity and connected car available in Germany. I don't know if you remember that. You mentioned that while you're driving, because of this 5G connected services, you can predict on what timing the traffic signal will turn red. And then if you have this information reflected on your navigator, you don't need to speed up even if you are in a hurry, because you can correctly predict the exact time you will arrive at the destination and something like that. I thought that was so interesting. So I rented a car last month when I participated in the IPPC Europe, and I enjoyed the latest 5G connected car that is unfortunately not available in Japan. So when I hear someone from the industry say, "Oh, we are now in the position to get the most out of 4G connectivity," I feel it really scary, because that shows that Japan is, as you said, far behind the development of auto industry in Europe, and also China and also Korea, because they are apparently behind the development. But when it comes to the other type of IoT equipment, I don't have such fear and the feeling of the latecomer or something. But on the other hand, I also have the concern about the patenting side, because the number of the ratio of the 5G filer worldwide, as your companies and statistics shows, Japan is far behind from the other competitors, and they are now trying to just make changes. And then, in fact, the Ministry of Internal Affairs and Communication has launched a project so-called Beyond 5G to encourage companies not to miss out on the 5G and then R&D on 5G and beyond. So I hope such the project will work.
Great. Now that's good to hear. I mean, to me, I think the beginning is always to identify the problem because only then you can solve it. And I think Japan has always been very self-critical, which is, I think, a good thing to push themselves further. And I see a lot of good developments in Japan, also in terms of awareness of connectivity and the importance of that. And one thing that I'm really jealous of in Japan is the SEP study group. I think we will need that in Germany as well. We should have that in any other country because
Wow.
it brings together, well, brings together the industry on that particular specific topic and discuss it and learn about it. And I think at least we haven't institutionalized it in the way that you have. So it would be great, since you have been involved in that group. I think you're also now one of the main organizers of these meetings and conferences that you do. Can you explain a little bit about what the SEP study group is? Who is participating and why was it set up?
Well, thank you for your compliment. And then, first of all, I would like to thank you for speaking at our workshop in the past. And then you also joined us last year after IPPC Asia. And well, so far, a number of people who have spoken at this SEP couch have also participated in the past. And then our group, we are a group of about 170 people at the moment. And it was actually established by METI back in 2012 when Apple Samsung case at the first instance court, which was Tokyo District Court, was pending to learn about the difference of SEP from the ordinary patent. So I recall that at the time, well, METI guys were so keen to get to know about the changes. And back to our members, most of them come from corporate intellectual property or legal departments, and we have good balance of both right holders and implementers participating. And other participants include METI, JPO, JFTC, and JETLO officials. And academics and lawyers are also involved. And I would like to highlight our unique feature because it's quite maybe strange from your view, and which is our study group is what we're going to do is that each time we have a Q&A session with an influential speaker, mostly from outside the country and sometimes inside the country. But the participants do not discuss or debate the topic on the spot. Well, sometimes they do, but mostly silent. And people from companies may find it difficult to express their opinions, even in their personal capacity. And well, it is common for everybody from the other companies worldwide. But it seems a bit sad to me compared to the German conferences where I had experience to attend, because both right holders and implementers are banging each other's opinions there. And I always see the very lively discussion, sometimes even dispute. But the real show at our study group is after the conference, after the meeting, at the bar, and where everyone gets so relaxed. And then when we go there, everyone is actively talking and discussing the various topic within or without the topic of the day. So it's very fun every time. And I really learn a lot of stuff from the conversation at the bar, actually. And then, do you agree?
I agree
You
because
were
I
part of
experienced
them,
it in
right?
December. Even better, when you sit in the restaurant and at the bar, you have to change your seat every once in a while. So you really speak
Right.
to everyone, which I thought was really, really good. And as you said, I think people are more open in bilateral discussions than in the group to speak up and criticize. And you can tell me if I'm wrong. Probably also part of your Japanese culture to be a little bit more, defensive and not so actively in public, pointing the finger at someone. So I think that is all appreciated. And again, we don't have such groups in Germany. I would love to bring
Oh, really?
170 SEP experts together every month and discuss SEPs. That'd be really good. That would help the ecosystem. Again, not to solve anything at the table, but to learn and discuss and invite people from the outside to explain. I can tell you in Europe, still there are lots of companies that have a very wrong perception on things. It's complex, I think. And I think at least in Japan, you try to grasp the topic and understand it until the very depth of it. So I think that's great. And again, I very much experienced that. So I think it's good. Keep up the work in Japan. Every time I'm there, I'll be happy to, if I'm invited to visit again. But I think
yeah, come and join us again, please.
I will do so, Shogo.
Yeah.
Great. This has been a great conversation, Shogo.
Thank you.
What I always have at the very end, I'll give you your final statement. What do you want our audience to keep remember from SEPs and the law in Japan?
I see. Firstly, SEPs are the fastest evolving issue of all intellectual property rights. You may agree to it and have a significant impact not only to the company's business but also on a country's policies such as security. That's why I believe that all parties must make efforts to promote licensing through analogous good faith negotiations, and nothing alternative so far. But litigation is the last resort. But I still believe that the formation of court cases will continue to be necessary to promote global negotiations and ensure predictability for the parties involved. We're working really hard to help Japan to be a part of that. So I hope you continue to look at Japan's development going forward.
Thank you so much. This was Shogo Matsunaga-san, one, I think, of the most influential SEP people in Japan. And if you are a Japanese audience, stay tuned. We have another Japanese event coming up on May 30th in Tokyo. You're very much invited to come. It's an open participation. You as well, Shogo. It was great talking to you, and I hope you listen in soon again. Goodbye.
Thank you.